Hi, I'm attorney Vincent Davis, and I've been fighting CPS for over 35 years. Through my years of experience, I've gained invaluable insights that I'm ready to share with you. If you're a parent or a caregiver or a relative, we need to talk. I'm offering a new opportunity for you to speak with me on a one-on-one basis. Ask me any questions, and I'll provide you with the insight you need to take steps in your CPS case. Members get everything they need to gain confidence and the knowledge that they need to support necessary to truly fight back. And as a special thank you for attending, I have a special offer just for you. Don't miss out, join us, and let's take that next step together. I'll see you at the question and answer event. All right, all right. Good afternoon. This is Attorney Vincent Davis, and I'm here having office hours about CPS matters, Child Protective Services matters, that are in every state in our country. I'm licensed in California. I primarily do cases in California, but have done cases in other states as well. Today, we're going to be talking about appeals. I was faced with a question this morning from one of my assistants, and this show is dedicated to Stephen. Stephen had a question about CPS appeals and about the trial court case. So let me give you an example. You have a jurisdictional and dispositional hearing in the CPS court. Assume that you lose. Once you lose the jurisdictional and dispositional hearing, you can file an appeal as a matter of right. And the Court of Appeals here in California has to make a decision about your case. Now, you start your appeal by filing a 2-page notice of appeal. And I think there's a mandatory form that you can use that's produced by the Judicial Council, and you can just type in appeal CPS case, and that form will come up if you just Google it. Once that form is filed, it notifies the judge and the Court of Appeals that you are now appealing this decision. And from that point, the clerk has to prepare the record on appeal. Now, what's the record on appeal? It consists of two things. Number one, it consists of all the social worker reports and all of the minute orders and any other piece of paper that was filed in your case during your trial. Okay, that's called the clerk's transcript. The second part of the record on appeal is called the reporter's transcripts, and that's the recording of anything that was said during your trial or even hearings leading up to your trial. So you have everything, and the Court of Appeals will have everything, and to review and to do your appeal based upon those records. Once the record on appeal is completed, it is sent to you. And then you have 30 days, you and your attorney have 30 days in which to prepare an appellate opening brief, an AOB. Once the AOB is started on, you're reviewing the record, and you might see things that are not included in the record that should be. And over the years, that's happened to me many times. And in that case, you have to make a motion to augment, keyword, augment, add to the record on appeal. For example, the last time I think we were involved in a motion to augment, the clerk of the Superior Court who prepared the record on appeal had inadvertently left out some of the minute orders. So we wanted to add those minute orders back in so that the Court of Appeal would have a complete picture of what happened in the trial court. Once the record is complete, your AOB is complete, you file it with the Court of Appeals. Now, the AOB, there's a lot of rules for the appellant's opening brief. You know, the page limit, that type of thing, the font size. You have to do legal research to determine what are your best issues on appeal, and you have to come up with the cases and statutes to support your legal argument. A good appellant's opening brief is at least 30 pages, in my opinion. All right. So this is not something that you may wave a magic wand and the appellant's opening brief is done and completed. It's a major piece of work. Okay. It can take anywhere from, I'd say, 20, 25 hours to 40 hours or more to produce a good appellant's opening brief. Now, once the appellant's opening brief is filed and served on all the other parties, then they have 30 days to file their respondent's brief. It's basically a response to your appeal. Once that is received, you as the appellant will want to review it and perhaps file what's called a reply brief. That is a brief you file in response to the in response to the respondent's brief. Okay? Once that is filed, the court, usually within 90 days or so, will set what's called oral argument. That's where you show up to the Court of Appeals and you orally argue your appeal. All right? Once that is done and oral argument is complete, the court has, I think it's 90 days in California, to make a decision in writing. They actually have to make a decision in writing, and they'll email it out to everyone. Once it's emailed out and a certain amount of time goes by, something is issued called a remitter. Okay, that means the appeal is fine. The appellate decision is finalized. Note that there's some time in between the decision being mailed out to everyone and the remitter being issued, because one of the things that you can do, or several of the things you can do, is you can challenge challenge the court's decision. You may want to make a motion to have the decision reheard by the Court of Appeals, or reheard in bank, which means that all the justices in that division are present and able to vote on the case. That doesn't mean they will, but you can make that request. Once the remitter is issued, the case is finalized, and it's sent back to the trial court to inform the court of its decision. If you're not happy with it, you or the county will file what's called a writ, W-R-I-T, to the California Supreme Court to appeal it to the Supreme Court. There are a lot of rules that you have to comply with to do that, and a timeline. And then from there, if you win or lose, you can actually file a writ to the United States Supreme Court. Have I ever seen cases appealed to the United States Supreme Court? Yes, I have. And there's one or two kind of famous cases out of the United States Supreme Court that involved juvenile dependency or CPS types cases. So it's not far-flung, or it's not impossible to have your case before the federal U.S. Supreme Court. Doesn't happen every day, but you do have that opportunity to try. Now, that takes care of the appeal, right? So it's more than just filing that 2-page notice of appeal. If you were to determine how much work you put in an appeal, filing the notice of appeal is probably 1% of the work that you have to do. I think we were talking to someone today, and I think they were under the impression that once they filed the notice of appeal, nothing else had to be done, and the Court of Appeals would just make a decision. No, not correct. It's a very involved process. Okay? Now, while that is happening, your case is still moving along the train in the trial court. So, for example, if you file a notice of appeal, your case is on appeal, but your trial court case is still going on. And if you lost the jurisdictional and dispositional hearing, you have to implement a strategy to get the children back. I recently had a strategy meeting with a client and my co-counsel about all the things that we needed to do to get the children back. I wish I had videotaped it. I think I did videotape it because it was a Zoom call. and I think we videotape it to send the client the call. Hey, Grace, try to find that video that I did of a Zoom call with Attorney Bowie and the client, and see if we can perhaps edit out, the client's name and everything, and make that into a video, because it was a very thorough going over of what to do now in order to get the kids back. Right? A lot of people think, oh, all I have to do is comply with the case plan, and I'll get the kids back in 6 months. No, that's not true. There's a lot more involved in it. So you need to make sure you hook up with your court-appointed attorney or your private attorney to develop a plan to get the kids back at the 6-month hearing, the 2-1E hearing, or before. My plan in the case I just told you about is to file something probably at the 2 or 3 month date, 388, to accelerate getting the children back, even though we lost the trial, the jurisdictional and dispositional hearing. Okay? One last thing I want to tell you as an aside, and it just found out today that we probably are going to win a trial that's scheduled for next week. And the reason why we're going to win a trial is because the social worker has changed her position in a written report, because we pointed out earlier in the case that unless the social worker has evidence, clear and convincing evidence, that you're a substantial danger of to the children, and there are no less restrictive alternatives, the children have to be returned to you at the disposition hearing. I'll do another show or office hours about the dispositional hearing, but I want to, I've been telling people that to educate them and alert them, because I think sometimes, people don't realize what the law actually is, and they make decisions at the dispositional hearing based upon their gut level feeling, or based upon the wrong burden of proof, or based upon the wrong legal test. Okay? All right. That's all I have for office hours today. Let me see if there were any questions. Anybody post any questions? No. We just have Crystal saying hello to me. Hey, Crystal, how are you? Good to see you. All right. That's it for today. I want to thank everybody for watching this video. There's one other thing I forgot. We talked about appeals. When you see this post on social media, either YouTube or Facebook or wherever you're going to see it, also attached, probably within the next hour or so, is going to be a sample of an appellate's opening brief that we did in an actual case. The names are going to be blocked out, of course, and the case number will be blocked out, but you will at least see something of an appellate's opening brief, and you will get a feeling for what I'm talking about in the abstract. I'm just, talking words you probably have never seen in appellate's opening brief, but I want you guys to be able to see it, say, oh, I get it now. All right. Alrighty. Again, if you have any questions for us, give us a call, 888-888-6582. And don't forget to look for the free handout, the free sample of the appellate's opening brief that we're going to post with this within the hour. Hey, Grace, did you get that appellate's opening brief from Arlene to post? I guess Grace isn't paying attention to me. Oh, Grace says not yet. Okay. Well, Grace, after the show, which is now, go ahead and call or email Marlene, because I instructed her to send you a copy of a brief that we did in an appellate's opening brief for a CPS case. All right, everyone. We'll probably see you tomorrow for more office hours. If you have topics that you want me to cover, email Grace, GRACE, at vincentwdavis.com. Oh, here's a question. Let me answer this question. JD says, do you assist with Hague? Absolutely, JD. I'm going to tell you something. It's funny that you mentioned that. I have a published case in the Ninth Circuit Court of Appeal about the Hague, International Child Custody Disputes. Many years ago, I did a trial in federal court all about the Hague. And I won at trial in the other side. And at that time, he was a very famous Hague trial attorney, an appellate attorney. He lost and he was very upset about his loss, and he appealed it to the Ninth Circuit Court of Appeals. And we won in a published decision. The name of the case, because it is public knowledge, is called Papakosmas versus Papakosmas, Ninth Circuit Court of Appeal. And I think it was also a published decision in the federal court, FedSup Reporter. So you can find that case and the opinions. You can just Google it. Papakosmas is how it's spelled like it sounds. Okay, JD, so look it up and give us a call if you have any questions. But hate cases are international child custody disputes, and there's special rules and special laws about them. And I've actually done a Hague trial in federal court. And after I won that case and I won it on the Ninth Circuit, for years, I had attorneys calling me, asking me questions about this or that or the strategy, blah, blah, blah. But anyway, JD, how much to retain? I don't know. You would have to give me a little bit more information. Is your Hague case in federal court? Is your Hague case in state court? Are you alleged to be the good guy? Are you alleged to be the bad guy? What's the basis of this whole Hague case and why somebody's trying to do it? And he says total approximate amount. That it's hard to say. If I have to do a Hague trial in federal court, you're probably talking about a retainer anywhere from $20,000 to $30,000. They're very expensive. They're very long and complicated trials. Okay, Deidre Payne says, hello, Mr. Davis. Hey, Deidre, how are you? Are you still doing shows on my YouTube channel, Deidre? JD says, California mom took to UK. Okay, so JD, you and the mom, you live here. Mom took the kid to the UK and probably tried to get orders of custody for the kid in the UK. So that's the classic Hague case. The Truth Movement says, I went to the dentist's office and they rooted me, so I decided to take my daughter and left. They called CPS on me. The Trust Movement, there's a book, Google this, Medical Kidnap, former CPS social worker, and it tells how CPS uses doctors and dentists to take your children. Medical Kidnap. It's on Amazon. Deidre says, yes, I am. I'm doing shows. Oh, everyone watch Deidre's show Wednesdays at 5 p.m. Deidre is a former CPS parent and victim, and she's working to get back one of her children, or two of her children now. Yes, I'm Kelly, Mom UK, okay. With Akima as Akima from New York is your co-host. Oh, Akima, that's right. Akima is a lawyer in New York, if I recall correctly, and she has a CPS case. And then JD says, Mom got restraining order for life against JD. For life? I didn't even know you could issue a restraining order for life. A criminal order, I think, was only good for 10 years. All restraining orders have to have an end date. And by the way, JD, if things change and circumstances change, and I'll tell you how you can help do those changes, you can go back to court and dissolve or modify your restraining order. All right. That's all for today. Thank you, everyone, for watching. We'll see you guys tomorrow. Bye-bye. Hi, I'm attorney Vincent Davis, and I've been fighting CPS for over 35 years. Through my years of experience, I've gained invaluable insights that I'm ready to share with you. If you're a parent or a caregiver or a relative, we need to talk. I'm offering a new opportunity for you to speak with me on a one-on-one basis. Ask me any questions, and I'll provide you with the insight you need to take steps in your CPS case. Members get everything they need to gain confidence and the knowledge that they need to support necessary to truly fight back. And as a special thank you for attending, I have a special offer just for you. Don't miss out, join us, and let's take that next step together. I'll see you at the question and answer event.